I don't disagree with him in a vacuum, but the problem is there are two cases really going on. We've got the Horry County corruption aspect, which is at this point beyond debate. It's acknowledged by Horry County. In this investigation, they have fired their number 2 man at Horry County. They fired a 23-year veteran of the force for corruption in this case. My client has a First Amendment constitutional right to address this important public issue. I suspect these people are here today more because of that issue and the covering up of what happened on in this shooting incident than they are necessarily to do with the death of Scott Spivey, which is tragic, and I'm not minimizing that at all. But there are two very important things going on here. But I can't talk about the things that Mr. Moss is referencing in generalities, which is the only way he wants to do it. Generally, I agree with the rules are lawyers shall not make these public statements, but there's 7 exceptions, Your Honor. And we can't make a statement unless someone else makes a public statement that misrepresents the facts. Mr. Lee, to the Post and Courier, his client repeatedly publishes these manifestos on Facebook. So I can go, if every issue they have with what I've done in this case, well, they should file a complaint with ODC if they think I violated the rules. But I can point, Your Honor, to the statement that was made that preceded anything I've done in this case. I will follow the rules. I think it's incumbent on Your Honor to report me if I violate the rules, but thus far, I haven't violated any rule as it relates to pretrial publicity. So I agree with him, the rule is generally what the rule is, but there are specific limitations to the rule.
Judge, let me say, I think this is a good time to say this. There's not 2 cases going on here. I would disagree with Mr. Tinsley. Whatever the Horry County Police Department did or didn't do in that investigation by SLED, if it is or isn't taking place, isn't what this case is about. The facts of this case are clear in the record. They're clear in the record. They are not, and I predict to you that when this is over, you will see they're not impacted about whether or not the Horry County Police Department acted properly or improperly. What we've got here is Mr. Spivey. There's the events that occurred before the shooting occurred, and then they want to talk about the investigation after. But that's okay. But any allegations of corruption, which is tried to blend into this case to impact the facts of the case, is wrong. Mr. Spivey, the facts are clear in the record here. And you need to know these things, I think, because as you said, you know less about it than anybody.
That's correct.
But all of this started when Mr. Spivey went to Boardwalk Village Bar on the afternoon that this occurred, and from approximately 1 o'clock to 5 o'clock, bought 11 different alcoholic drinks. He got on the road driving under the influence down Highway 9, waving a pistol, and there's photographs of this, repeatedly at other motorists, at least 4 motorists, weaving in and out of traffic, speeding by, braking, and in the words of the witnesses who called 911, which we'll talk about in a minute, and others, was a great danger on the roadway. It instigated any contact that there was between my client, who is Mr. Williams, and Mr. Boyd. He then stopped his automobile as he pulled off the side road, and they want to say they were in contact with each other for some maybe 7 to 10 miles down Highway 9 in Horry County. Now, that contact again was initiated by Mr. Spivey for reasons satisfactory to himself. Nobody else. Multiple witnesses to that. The 911 calls that we're going to ask you to admit into evidence detail that in great detail. Mr. Boyd, who is Ken's client, about 5 miles into that following or interaction between the two of them on Highway 9, called 911, said there's a guy pointing guns at everybody. You need to get somebody out here. So with that, he stayed on the telephone with a 911 operator till the shooting occurred. But both of them were all headed down Highway 9 towards Loris, South Carolina. Nobody turned around and followed or chased anybody. They were both headed in the same direction. And then Mr. Spivey's action initiated the problem. And then when they pulled off to the side road, Mr. Spivey jumped out of his pickup with a pistol, pointed it at Boyd and Williams, who had followed behind him and had stopped a distance back, shot the gun, and they shot back. And Mr. Spivey was tragically killed. Now those are the facts that you're going to find on the ground. He was shot under the armpit.
All right, let's don't get too deep in the facts. I want to resolve this issue of protective order first.
Okay.
Yes.
Well, we're good with protecting everything. Everything. Nothing goes except to the lawyers. I disagree with Mark about it's a First Amendment case and they're entitled to this and that. These defendants we represent are entitled to a fair trial on the facts in the record. And all of this that is permeating out there will, if this does go, could to you as a finder of fact, and could to a jury as a finder of fact, go to impact or impair or interfere with their free judgment of the facts by getting information that is incorrect, wrong, misleading, and that's what we're worried about. This is out of control.
All right, what I want to do is set some ground rules on what we're going to do from this point forward. I think it's unfair to anyone to try to case in the press, so to speak. So, can we, would y'all agree that a protective order would be appropriate for whatever discovery each other are asking for?
Yes.
All right.
Well,
Please.
You mean going forward?
Yeah, go on.
Yeah.
I can't undo what's happening.
Let's talk about how we're going to try the case, because I think that gets to what they want to do, if that's okay with you, Your Honor.
All right, make sure I'm with you. Next step would be prepared, ready, present, stand your ground here.
Yes.
Is that right?
Correct.
Okay. So let's talk about logistics, getting ready for that, and timing and that sort of thing.
Yeah.
The best roadmap that I have seen, and you've got way more experience in this than me, is the Supreme Court's order in the McCarthy case, where they lay out the things that you are supposed to find facts on, that you're supposed to judge the credibility of the witnesses, and which makes me think, when you read those appellate decisions and the appellate court says that the trial court was in the best position to see and hear and assess the credibility of the witnesses, it sort of sounds like you have to take live testimony. Now, does that mean that we can't go and video depose somebody, designate portions of the deposition, whether it's written or video, and give to you? I mean, I think that there's a way to deal with some of this expeditiously, and then I would propose, makes sense to me, we get that done. They brief their argument, I respond, they reply, we have a hearing. And if there are live witnesses that need to be called, then we'll deal with that. But that seems to me to be a way to do it. They may want to just say, no, we're going to bring everybody in here, and that's fine too. I'm just trying to address it most efficiently.
All right, let me hear from passenger first, and I'll hear from driver.
Well,
That's how I'm keeping track of y'all.
I don't-
The passengers are on the ends and the drivers in the middle.
They all drove different cars, so I guess nobody can get along with anybody else.
Well, you got.
we're trying to
you got
stimulate
North
the
Portal Beach,
economy by
Little River,
burning more
Conway,
gas.
Marion.
That's
Three
right.
different places.
Yeah, you don't know where we came from, do you? Okay. I don't really disagree with what he said there. There is a clear roadmap for you as a judge on how to conduct a stand your ground hearing. And the most recent rulings by the Supreme Court made a significant change in which they said this is not a hearing for a judge can sleepwalk his way through it and just pass it on to a jury. that by default, that's wrong. That the circuit judge has to make findings of fact.
Which case you referring to?
Well, there's a McCarthy case, and then,
Yes.
there is that, and then there's a case on appeal right now for the stand your ground hearing I had, O'Brien and I had in Myrtle Beach, where Judge Hayes issued the order. And I'll get you the exact case if it's other than McCarthy, but it's clear that you have to make a determination on the finding of fact, the preponderance of the evidence, and all of that. So it is a trial by you, even though it is a hearing. So our thought would be, is that this would be a case in which, a hearing within the trial in which there would be live testimony presented, there may be video presented, audio presented, 911 call testimony, the whole gamut. One of the things that we're dealing with in this case, and I'm bringing it up now because I think it's relevant, is there are 3 911 calls. 2 of those calls were made by Blaze Ward and Frank McMurray. One lives in North Carolina, one lives in Virginia. And frankly, since I've been involved in the case, at least, they've gone missing in action as far as availability to talk to me or to anybody on the defense side of this. Now, we believe, and we've got a motion for you in limine, that we can present their testimony, critical testimony, couldn't have this without it, by way of the 911 call. I think it's clearly admissible. But we want to get that ruling as soon as we can, because it does appear to us that these witnesses will have to be compelled by out-of-state subpoena and order.
What about the request to get the hair sample, blood sample, where it was from the Horry County Police? Do you objection to that?
Yes. One is, it's mainly the cost. What his motion says is that we can both get our independent experts. If you read McCarthy, the sole focus is on Weldon Boyd and Mr. Wiggers. Are they without fault in bringing on the difficulty? Do they satisfy the elements of self-defense? Nowhere in the analysis, in any of the cases that I've read that address the issues, is what my client may have taken months before, years before, whatever a hair follicle test may show. Now, they tested his blood, Horry County tested his blood for the steroids that were ultimately in the vehicle after his death and after the body cameras were turned off. But there are no steroids in his blood. Their expert was deposed last week, who said that he didn't need what it is that Mr. Martin is asking for. I don't need a hair sample. My opinion is what my opinion is, and I don't need that information. So they got an expert, they say what they want said, and it's irrelevant. Because if you read McCarthy and the things that this court has to consider, what starts the fight in this road rage, if you had a bad day, your wife screamed at you because you snored last night, got nothing to do with whether or not the defendants are without fault in bringing on this difficulty. Did they chase him for 9 miles, shoot him when he got out of his vehicle with his slide locked back? And that's what is the consideration, not the why. The why they started an argument 20 minutes before.
But then that's what you're saying, the hair follicle, their expert looking at it, they've got an expert. You say, he said, I don't need it, but if they want it.
They're talking about a new expert now.
Yeah.
So
So,
my client has an expert, Mr. Martin's client is not. He may get it wrong.
Well, we do have one.
but doesn't that go to weight?
I'm sorry?
Yeah,
Wouldn't that go to weight of the
Judge.
evidence? Just simply, 30 days ago, we can't look past that, so we don't know what's going on, or 30 days ago, this, all that sort of thing.
to some extent, I agree, Mr. Tension.
Let me sit down.
Okay, you sit down. All right. It does for the large part that matters, what happened when before the last shot was fired, okay? But in this case, as it would have it, there's gonna be great, I predict, discussion about whether Mr. Spivey did or didn't do what some of these witnesses says he did do as he was driving down the road. So why, was he acting that dangerously or erratically? Was he waving a gun? Of course, there's pictures of that. But all that comes into, okay, well, did he do that or why would he do that? He's a nice guy. He's a normal guy. He wouldn't be driving down the road under the influence or waving a gun or trying to run other people off the road, which is what the witnesses are saying. So as fate would have it in this case, when they searched that vehicle of Mr. Spivey's, they found the bag with 26 pills in it that Mr. Tinsley just says somebody planted in that truck, which I will tell you there's absolutely no evidence of that I've seen, and if he's got evidence of that, he can share it with you right now. But those pills were steroids. And there is the road rage syndrome, documented existence of that out there that would cause, we believe, it may cause Mr. Spivey to act in addition to the alcohol he was drinking in this erratic, dangerous way. Now, just so you are clear, the expert did testify, and the expert that I've talked to would testify that whether or not there is any steroids in Mr. Spivey's blood or his hair at the time that this occurred, that still doesn't mean that if he used them months and years before, that they could manifest themselves that day. So we will have that argument whether or not there is any active steroid in the hair or not.